Welcome back to Breaking History, the Supreme Court Historical Society's show where we highlight modern scholarship about the Supreme Court's endlessly interesting past. I'm Ross Davies, and today I am joined by the Honorable Mathias W. Delort. Justice Delort has enjoyed a 40 years and counting distinguished legal career in Chicago. He was in private practice from 1985 to 2007, and then served in the Illinois judiciary for 16 years. First on the Illinois Circuit Court in Cook County from 2007 to 2012, and then on the Illinois Appellate Court First Circuit from 2012, until he retired in 2023. He now serves as an arbitrator, mediator, and court-appointed neutral. He is, in other words, a pillar of the Illinois bar. Today, however, we probably will not spend even a minute talking about the high offices in which he has served, the important cases that he has judged, or exploring the work of a senior lawyer in Chicago nowadays. Instead, we are going to focus on a short, intense episode back in 1990 and 1991 when a young Mathias Delort, an associate then in a small suburban Chicago firm, was working day and night on a Chicago election dispute that culminated in the Supreme Court's 1992 decision in the case of Norman versus Reed. The full story of the case and of young Justice, then not yet Justice Delort's involvement in it is told in his article titled Behind the Scenes of Norman versus Reed with Justice Stevens, How a Local Chicago Political Battle Resulted in an Unlikely and Rare Supreme Court Case on the Rights of New Political Parties. Justice Delort, welcome to Breaking History.
Thank you very much, Ross. I'm very glad to be here and talk about what you have aptly characterized as a very interesting episode in my life.
Very good. Well, we better get started. So let's go ahead and plunge in. Perhaps you could start by giving us a bit of orientation about the essential facts in Norman versus Reed, which, just to be clear up front, are very complicated and will need to be abbreviated today. But the full story, again, is worth reading. The short version is there was an election, and then there was a dispute about it, and then it ended up in court, and you were involved. What happened? How did you get started in all of this?
Well, I got started because I was an election lawyer. It's a sideline for almost anybody who is in that field. I was working at the small suburban law firm you mentioned, and my boss was retained to represent the Cook County Officers Electoral Board, which is an administrative agency, and it was in the process of hearing objections to nomination papers. And what I mean by that is that there was a third party running for various Cook County offices that year. The third party was named the Harold Washington Party, named after Chicago's first African-American mayor. There was a great deal of political strife at the time in the Chicago and Cook County political worlds, and some people felt that this was an avenue for them to express their frustration with the other two parties and perhaps to gain election to office under that label. Needless to say, the Democratic Party of Cook County was not thrilled with the concept of this new party perhaps siphoning off some of their votes. So they challenged the Harold Washington Party candidates on numerous grounds, only about two of which ended up surviving when all the litigation was over.
Go right ahead. Carry on. It's already a cliffhanger.
Yeah. So this was all during the summer of 1990 and in the early fall. My boss and I split up the work. He appointed me as a special state's attorney of Cook County so I could work on the case. And he attended the hearings, which were in downtown, of course. And then back at the office, I was churning out motions and orders and opinions and memoranda to brief the board members on various things that were going on. This was not quite a 24/7 case, but it was close to it. It went on in terms of the hearings for days and days. And recently I got the file from the court warehouse. It was just banker box after banker box of paper. So you can imagine what was going on at the time.
May I interrupt for one moment
Sure.
and ask just, and this is sort of speaking as someone who was once upon a time a young lawyer as well, was this one of these situations where you were basically a one-person show. You were expected to know everything and do everything behind the scenes.
Well, I wouldn't call it a one-person show because my boss was, in fact, the one sitting at these lengthy hearings
Okay.
and dealing with the interplay between the board members who didn't quite all get along with each other and who also didn't necessarily agree on the various things that were going on. So he was on the front lines on that side, but I was the one who was cranking out all the paper. In a case like this, the paper is very important, especially when you're making a record, and the case was certain to go up on appeal. We didn't ever think it was going to go up quite as far as it did, though.
All righty, sorry to interrupt. Please carry on.
And in the end, the board split 2-1. It was a 3-member board, and the board voted, the board majority voted to remove the suburban candidates from the ballot of the party, but keep everybody else on. And there were essentially 2 aspects of that ruling that ended up surviving through the later appellate process. One was that the board held that it would violate the candidates' rights to freedom of association to prevent them from expanding the name of the Harold Washington Party as it already existed in the city of Chicago to the suburban area and to the county. The second aspect of the case was that the board also felt that under the recent United States Supreme Court precedent in the Socialist Workers case, the party could not be forced to file 25,000 signatures in each of the 3 segments, city, suburban, and countywide. That seemed to have been foreclosed by Socialist Workers, and we so held. So in the end, we ruled on countless issues, but those 2 were the ones that sort of framed the further appeals later on. Now, what happened next? In Illinois, a ruling like this by an electoral board can proceed through a process called judicial review, which most lawyers know as administrative review. It went literally across the street to our large courthouse, the Daly Center, and it was heard by a judge who was well into his 80s at the time. He had been first elected in 1954. He had had a very storied career on the bench, retired for quite a while, but then came back. And at the time, political hot potatoes like this were hand assigned to a judge in that division of the court called the county division. And Judge Wachowski, who was the judge in question, ended up getting hand assigned a lot of these politically hot cases. He was never going to be running for election again. And Judge Wachowski ended up ruling that the board was wrong. He held that all the candidates should be removed from the ballot and ruled against the board on both of those key issues I just mentioned. We knew that that was not going to be the end of the story. There was too much political push, involved on all sides for that simply to be the end. In the meantime, we're getting close to the election, and the ballot printing has been held up. It's stayed because everyone knows this is not quite the final answer. So what's the next step in Illinois? You go to the Illinois Appellate Court. Now, that's the court I sat on 30 years later. Okay? And I used to deal with these expedited election matters. And it was only in the appellate court for a couple of days. The appellate court stayed everything and expedited the schedule. But this Illinois Supreme Court granted a motion for direct appeal. It's very rarely done by the Illinois Supreme Court, and I don't recall any time they've done that in the last 10 years or so. But they do implement it in election cases once in a while. So we bypassed the appellate court and we're straight in the Illinois Supreme Court, which set an expedited schedule and an oral argument date in their Chicago courtroom, which is almost never used because the court normally sits in Springfield. But they sat over their summer break. They all came back and heard this fully after complete briefing in the fall of 1990. The arguments were what they were, and a few days later we received a quite unusual order from the Illinois Supreme Court. It was not in the form of an opinion as it normally is. It was in the form of a typescript order. The 4 Democratic justices formed the majority, 3 from Cook County and the 1 Democrat who was then from downstate. And they held essentially that Judge Wachowski was right, but did not give really any reasoning for that. It was a very succinct order, um, simply adopting, what he said. But the three Republican justices, who were all from downstate and suburban districts, they dissented. And their dissent was more in the form of a standard opinion. There were actually two dissents. They all joined each other and relied on socialist workers, relied on freedom of association, all the arguments the board had stated in its opinion, which is what actually I wrote. All right. And so we end up with a 4-3 Illinois Supreme Court decision. We all thought that that was the end of the story. The election agencies, for whom we were the relation in the case, we told them what the Supreme Court had ruled. Stay is lifted. The mandate was issued in stanter. Those are usually final kinds of kinds of language. And like they did in the old movies, they called up their vendors and said, roll the presses. And all the absentee ballots started getting printed up, and the pages for the ballot machines and the specimen ballots that are issued for absentee voters, they all started getting printed. And a few days passed, and it was a Friday. And unbeknownst to us, something happened on Friday, which I'll talk about in a second. But on Monday, I'm sitting at the office, and we're sort of packing up the boxes and saying, okay, time to move on to other work that we neglected over the summer while we were working on this. And my phone rang, and the receptionist of the law firm said, your boss isn't around, but I have a call from an Associated Press reporter who wants to talk to you about something about Justice Stevens in the Harold Washington Party case. And I said, okay. I always enjoyed talking to the press, and I knew what to say to them and what not to say to them. In a previous life, I was I did press releases for a state legislator. And so I picked the phone, talked to the Associated Press reporter, and he said, well, I have an order from Justice Stevens that says as follows, that in order to maintain the status quo, the order of the Illinois Supreme Court is hereby stayed, pending essentially further review by the court. And I said, hold it, read that to me again.
And now I got to ask, when you picked up the phone to talk to the reporter, were you standing up or sitting down?
I'm sure I was sitting down. Sitting down. Okay.
Because you were by the time the reporter finished reading that, if nothing else, right?
Yes.
Oh, my goodness. Okay.
And my brain flashed back to law school when we were taught civil procedure about how a final decision of a state Supreme Court can, in fact, go to the U.S. Supreme Court, even if the case had never been in federal court. Okay. And I sort of figured out what happened. I said to the reporter, I cannot make any comment right now. I need to see this order, and I'm going to talk to the client. So before I called the client, though, I called the U.S. Supreme Court because I wanted to make sure this wasn't a prank and that I was given the most accurate information possible. I frantically, in the days before Google, tracked down the phone number for the U.S. Supreme Court clerk's office, called them up, and it was almost like someone was expecting a call, because I was routed within about 60 seconds to someone who said, oh, thank you for calling. We were waiting to hear from you. We wanted to know, or Justice Stevens actually wants the Cook County officials to file something right away explaining what the status of ballot printing is and whether or not logistically they can implement a stay order and essentially put these candidates back on the ballot for the time being. Here's the special secret fax number we want you to use to send this. Okay. And I said, okay, thank you very much. Hang up the phone, and I took a breath and said, oh my God, Justice Stevens of the United States Supreme Court wants me to file something today. Okay. This is something not quite in the normal checklist of my daily work at this small suburban law firm. I talked to the county officials. I said, I need an affidavit. I need who it was going to be from, saying this is how much it's going to cost to do it, and this is how we can do it, or we can't do it, and this is how much it's going to cost, and this is the deadline by when we could do it logistically, given military ballots, absentee ballots, and all those kinds of things.
Yeah.
We got the affidavit, and they said, well, we can do it. It's going to cost about $1 million, and it's going to be It has to be by the end of the week or so. So we faxed that back to Washington. And this is something I didn't say in my article. We faxed it to Washington. I got a confirmation of the receipt of the fax and didn't hear for a few hours. And then finally, I forget if I called or they called. And somebody who was not very happy at the Supreme Court said, you were supposed to fax that to us. We never got it. And I think, oh no, this is the U.S. Supreme Court telling me I didn't do something. So I checked the fax log. It showed up as being properly received. I called back very apologetic, saying, I'm showing this as received at such and such a time. Well, and they said, send it again right now, because we're going to be standing by the fax machine waiting for it. Said, okay, we faxed it again. Phone rings again, and the person, who is now in a completely different mood, says, we're really sorry. The fax machine was jammed, and your response crumpled up like an accordion in the fax machine. The first response. But we cleared the machine. What happened now is related in the article and is shown through Justice Stevens's papers. Justice Stevens wrote a summary order completely reversing the Illinois Supreme Court, and without even waiting for the other side to chime in. Okay? He thought this was so wrong. It was so clearly violative of existing precedent. He circulated it to the court, along with the stay order. Members of the court pushed back a little bit, saying, we think you're right, but let's wait to hear from the other side. Let's give them a shot. In the meantime, Justice Stevens on a Wednesday says, okay, I see I'm getting some pushback here. I'm going to suggest a stay order for the full court to enter. And his papers reflected every single justice who was sitting on the court at the time joined in the stay order. And rather than waiting till the Friday conference, they actually issued it on Thursday. So the stay order issued on Thursday specifically cited the Electoral Board's decision that we wrote and said this is what's going to govern the election, pending the filing of a petition for writ of certiorari, which everyone knew was going to take some time.
Yeah.
So the election proceeds. This is only a couple weeks before the election. By virtue of the U.S. Supreme Court stay order, the candidates stayed on the ballot, except for the suburban candidates. Although Harold Washington candidates lost the election, but they gained about 12-15% of the vote, which theoretically was siphoning off some Democratic votes, but the Democrats still all won all the seats except for one, which was state's attorney, which was run by a Republican who served, ended up serving actually 2 terms. In the meantime, we take a breath. We think we're not quite done yet because there's still the filing a petition for writ of certiorari. The candidates filed. The election board filed, and eventually the Supreme Court granted the petitions for writ of certiorari and consolidated them. By this time, Cook County has a new state's attorney, and there was no longer theoretically a conflict preventing the incumbent elected state's attorney from representing the county as he normally would. They moved to terminate the appointment of our law firm. I was the lucky guy on short notice who had to go down and come up with a coherent argument as to why not. I lost. But nonetheless, the state attorney's office continued using us as special state attorneys because we had the institutional knowledge. We had the files. We had sat at the hearings. We had written the opinions. And
it was you two guys. It was you two who had done all that work, right?
Yes. And we were standing by to see what would happen with the cert petitions. Months go by. And Justice Stevens' papers reveal that Justice Blackmun said, let's hold off on this because we're still waiting for the Illinois Supreme Court. No doubt they're writing something very scholarly explaining why they did what they did. Flash forward 40 years later, they still haven't. Okay. But a week later, it comes up at conference, and 2 justices vote to grant cert originally. You can see by the black check marks. But then there are 2 red check marks next to 2 black ones because 2 other justices apparently were persuaded by Justice Stevens to grant cert, making the magic 4 justices. We were notified and we said, okay, we're going to the U.S. Supreme Court on the merits. The election was over, but we knew the public interest exception would apply for various reasons. And Then the state attorney's office decided that we were not going to argue this case, even though we had written everything to date. And um, there was some strife about that. But nonetheless, the case was set for argument in October of 1991, almost a year after the election was over. And we all went to Washington. The counsel who was going to argue for the state attorney's office was the first assistant, a retired judge named Ken Gillis. And we briefed him as well as we could. But I was already a member of the Supreme Court bar, so I was able to sit right in front, although not at counsel table, and got ready for the arguments. I thought that this is never going to happen to me again in my life. All right. And during the arguments, there were questions from the bench, as one might expect. And I'm sitting there thinking, I wish I could answer these questions. I really do, because I know the answers much more thoroughly and explicitly and in granular detail than the people who are arguing this. Frustrating, yes, but it's life. It's life as a lawyer. Sometimes the boss gets to argue. And this guy, it wasn't even my boss. It was somebody who had just sort of parachuted into the case. Mm-hmm. Nonetheless, a few months later, we get the opinion from the full court. It was written by Justice Souter, who was relatively new on the court at the time. And Justice Souter essentially held that the Electoral Board got it right.
Which, correct, if I may interrupt here for a moment, yes. Which means Mathias Delort got it right.
And of course the client,
That's right.
We had three very active board members who understood the issues pretty well. Mm-hmm. All three were lawyers. One of them was a very accomplished election lawyer, who was the incumbent county clerk, Stanley Cusper, and he was in the board majority. We knew how this should come out. Mm-hmm. We wrote it up, and it went up the flagpole a number of different levels, but it was certainly gratifying to see in the end the U.S. Supreme Court said we were basically right. And what that meant logistically was a couple things. One, it meant the Harold Washington Party became an established party in Cook County for a while, which they had equal status with the Democratic and Republican parties. It was an important case for the rights of third parties, although it really didn't set any new precedents. It simply adhered to the existing precedents. And as I opine in my article, I think the only reason the U.S. Supreme Court did what it did and took the case and granted stay in the beginning, rather than sort of say, okay, not interested, was because it was Chicago, and Justice Stevens knew Chicago, and he said this was wrong, and we're going to make it right. And in the end, I think that's what happened. I ended up practicing law in another firm for quite a while, went on the bench, as you said. But I always remember after the Justice Souter's opinion came down, I wrote in my calendar, my electronic calendar, eventually, write law review article about Norman versus Reed. I said, this is such a great story. I have to tell the backstory of it at some point. Well, life catches up with you. You have law firm number one, law firm number two, a bajillion clients, a number of election cases along the way. And I kept putting it off. I kept getting copied on my calendar from year to year. And then as a younger lawyer, I realized that papers of the U.S. Supreme Court justices are often released following their death. And I said, let me park this on the back burner for a while until somebody's papers are released who was sitting on this court. And flash forward to about 2020 or so, Justice Stevens's papers were in fact released by the Library of Congress. I was in Washington for a speaking engagement, and I added an extra day to the trip just for the purpose of going to the library to pull the file and take whatever time it was needed to figure out what happened behind the scenes. And the file was, of course, very complete, handwritten notes, the red ink, the black ink. Robert Carroll, who the famous historian, says, always look on the other side of the sheet, because sometimes there's notes. Okay, so I did that as well.
This is a really valuable contribution. And again, thank you very much for it. And thank you to everyone for joining us for this edition of Breaking History. We will be back soon with another new and interesting look at the past.